thank you for braving the cold and the Brussels traffic to come to the basement venue, and thank you to so many of you for coming. Welcome to our panel on a US GDPR prospects for legislation, regulation, and adequacy. I'm Neil Richards. I'm the moderator today, and I am the Cope Distinguished Professor of Law at Washington University, which is in St. Louis. It's not in Washington State. It's not in Washington, D.C. It's in the middle of the Mississippi with steamboats and Mark Twain and Budweiser and an arch. I'm the co-director of the Cordell Institute for Policy and Medicine and Law, which is sponsoring this fantastic panel, which tackles one of the biggest issues in privacy law today. So after decades of failing to pass a comprehensive and, dare I say, adequate baseline privacy law in the United States, there's more optimism today about realistic privacy reform than there has been in some time. A big part of this has been a result of America's many privacy scandals, most notably but not exclusively the Cambridge Analytica scandal, and also international pressure from the GDPR's adequacy requirement and vertical pressure from state laws like the California Consumer Privacy Act, or CCPA. Unfortunately, while the United States is poised to act on privacy, its lawmakers cannot agree on what to do, though perhaps it's not the greatest disagreement America's lawmakers are facing this week. So on privacy, there are a range of options facing America's lawmakers. America could choose on one hand a data protection model like the GDPR in a strong form that is protective of fundamental rights of privacy and data protection. Or it could choose a watered down, what some of us call a GDPR-lite model. Alternatively, it could choose to do something entirely different, to go in a consumer protection direction, imposing substantive rules to protect consumer trust. And any federal regime, no matter whether strong or weak, broad or narrow, could choose to preempt lower state level rules, or it could work in tandem or in some version of harmony with them. And then finally, of course, any US privacy regime, whatever we might get, including the current one, raises important questions of adequacy and interoperability. So we're here to take on all of those questions in the next hour and 10 minutes. And we are joined by a truly all-star cast of American and European privacy regulators, lawyers, and academics. Let me introduce our panel before we dig in, though I'm sure many of them, to most of you, need no introduction. In fact, though they're all very, very nice people, which is objectively true, in addition to being brilliant and distinguished, I'm going to do them in alphabetical order to avoid any potential protocol issues. So starting on my left, we have Julie Brill from Microsoft. Julie's the Corporate Vice President, Deputy General Counsel of Global Privacy and Regulatory Affairs, and Chief Privacy Officer. Julie currently leads Microsoft's international work, as it says in her bio, to, quote, elevate privacy as a fundamental human right, which I thought was quite striking. Before joining Microsoft a few years ago, Julie spent 3 decades in public service, including most notably a tremendously successful 6-year stint as one of the commissioners of the Federal Trade Commission in Washington, where Julie worked on many issues of critical importance to consumers, including privacy, fair advertising practices, financial fraud and competition. Hi.
That's very discreet.
We are not having a pitch invasion. This is our 5th panelist. Hi, Bruno. Thank you. And Julie became known as one of the most important and influential minds on privacy anywhere in the world. So we're delighted to have you. Speaking of influential regulators, our next panelist is Commissioner Helen Dixon, the Data Protection Commissioner for Ireland, a position she's held since 2014. In her current job, Commissioner Dixon is responsible for upholding the rights of individuals regarding how data about them is used. As I'm sure most, if not all, of our audience is aware, this role, among other things, requires the regulation of a large number of American internet multinationals with European bases in Ireland, most notably Facebook, which the DPC's office has been involved in numerous investigations and court cases with, including the high-profile Schrems litigation currently before the European Court of Justice in Luxembourg. Welcome, Helen. Next, and most suddenly, we have down on the end, we have Bruno Gencarelli, he heads the International Data Flows and Protection Unit at the European Commission. Bruno led the Commission's work in the area of data protection in the decisive phases of the negotiations of the GDPR and the EU-US data transfer arrangements. In that capacity, he's headed the Commission's delegation in interinstitutional negotiations with both the European Parliament and Council, which gave us such things as the GDPR and the Law Enforcement Directive. And if that weren't enough, Bruno was also one of the lead negotiators of the EU-US Privacy Shield and also the so-called Umbrella Agreement, and recently negotiated the mutual adequacy arrangement between Europe and Japan, and is also, as if you weren't busy enough, in charge of the data protection, data flows aspects of Brexit. So welcome, Bruno. Our next panelist, next to Helen, is Woodrow Hartzog. Woody is a professor of both law and computer science at Northeastern University in Boston. Woody's research focuses on law and policy issues related to privacy, data protection, digital technologies, artificial intelligence, facial recognition, and trust. And I have to disclose at this point that Woody is also my co-author in a series of articles on trust, privacy, and data protection. So everything he says about those topics is just right. Anything that isn't right is his fault. Woody's a super prolific scholar. Most notably, his book, Privacy's Blueprint, The Battle to Control the Design of New Technologies, was published by Harvard Press last year. And finally, but by no means least, we've got Professor Bill McGeveran. Bill is the Associate Dean for Academic Affairs and the Julius E. Davis Professor of Law at the University of Minnesota Law School, just up the river from where I live in Minneapolis, Minnesota. In addition to numerous scholarly articles of excellent quality, Bill is notably the author of the leading American casebook, if not by adoption, but by quality, because I use it, on privacy and data protection law, called appropriately enough, Privacy and Data Protection Law. So welcome, Bill. So that's a lot of introduction. Let's get to substance. This is a panel on US law, so I'm going to ask our three Americans first to give us a 5-minute version of what they see as the lay of the land, and the potential avenues for U.S. privacy reform. I'm interested in three things here, guys. First, what's the lay of the land? Where are things currently? Second, what is likely to happen? And third, because I'm a law professor, because I'm an American-based law professor, what do you want to see happen? So, Bill, you've written a fascinating paper on this issue called Catalyzing Privacy Law with some co-authors available in SSRN. Maybe you could start us off. What do you see happening in the US right now, and what do you want to see happen?
Great. Well, thank you to Neil and the Cordell Institute and to all the participants in the panel for putting this all together. I think this is really a big moment for privacy law in the United States, and data protection law, although I don't myself see a grand, dramatic sweep of legislative activity just yet. And I'll explain what I mean by that. The paper that Neil is referring to is one that I have co-authored with two other US-based law professors, Margot Kaminsky at the University of Colorado and Anupam Chander at the Georgetown University Law Center, both of whom may be familiar to many of you. And we bring an interesting combination of backgrounds. Anupam is an international trade specialist who deals with information law. Margot has done deep study of the GDPR, including on a Fulbright here in Europe. And I do a lot of American regulatory law. And when we put our heads together, we asked ourselves what accounted for this sort of wave of American legislative activity. And Julie, I think, is going to talk a little bit more about the description of that wave, but suffice to say there's a great deal of action in the US Congress at the federal level when they're not busy debating the perfect phone call. And there's a large wave of state-based laws, the most prominent of which is the California law that Neil referred to, the California, the CCPA. Although Washington State came close to passing something last year, is definitely active this year, and there's quite a large number of other proposals in the states. I'm also pleased to be on this panel because I'm working with the U.S. Uniform Law Commission, which is an organization made up of state legislators and attorneys general and also practicing lawyers and academics. They're responsible for the Uniform Commercial Code, which is the main commercial state law in the U.S. They do a lot of other uniform laws. The model is that they create something and then they give it to state legislatures to pass off the shelf in the hope that if all the states pass essentially the same statutory text, our EU friends are familiar with this concept, then it will be, in theory, harmoniously administered and regulated. So I'm working now with the Uniform Law Commission on a new project to develop such a uniform statute in private sector privacy, adopting the scope of the CCPA, the kind of reach of the CCPA, but perhaps substantively going at it in a different way. So our paper looks at that wave of activity at the federal level, at the state level, in organizations like the Uniform Law Commission, and asks what's going on, what explains this, what's catalyzing this privacy action, as we say in the title. We talk about the Brussels effect and the California effect as both being at play. So descriptively, we talk about who is copying whom. We want to offer sort of a family tree of the descendants of the statutory language in the various statutes. And if you look at the Washington statute, particularly the new version that's just come out very recently, you can see parentage from both the California law, the CCPA, and the GDPR, often in the form of direct textual copying. So for example, the definitions of controllers and processors, concepts that have not been present in the US, are directly imported from the GDPR and placed at the center of the Washington bill. On the other hand, certain aspects of the mechanisms by which the bill functions are copied often in substance and occasionally in text from the CCPA. So you see language coming from the GDPR, although not exclusively. And you also see the GDPR being a part of the impetus for why now, right? Companies have acclimated themselves to a new level of data protection compliance, and as a result are perhaps more receptive or less unreceptive to regulatory activity than they might have been a few years ago. And some companies, Microsoft being one of them, are actually taking the lead towards promoting the possibility of uniform, sensible privacy statutes in the US. Some companies are GDPR-ifying their firm-wide operations, an economic Brussels effect where companies are adopting the compliance measures necessary for EU compliance in all of their operations globally. So the GDPR has some parentage of the text and some of the impetus. At the same time, I would say that the CCPA from California is the greater explanation for the impetus, and my paper with Kaminsky and Chander talk about this as well. The very pressing uniformity challenges within US compliance that are presented by the California law, which took effect this month, and the possibility of other states doing different things is definitely spurring at least talk of action in the federal and state legislatures. And the substance of the core mechanisms of these bills still resemble American privacy parentage, not European. And what I mean by that is I've long talked in the casebook that Neil mentioned and in my articles about a fundamental division between a consumer protection approach dominant in the US and a data protection approach that you see in the EU, especially in the GDPR, where European law is driven by a fundamental human right at its core. American law has been, and in these new proposals continues to be, driven by a policing of transactional fairness in individual interactions, not by a concept that there is a fundamental human right, which is not embedded in our Constitution and has not been part of American legal culture. And none of these laws does anything to change the fundamental defaults, which is to say, in Europe, you are only allowed to collect or process information if the law says that you can, if you can identify one of the legitimizing conditions under European law. In the US, you are allowed to collect or process whatever you please unless a law specifically tells you that you cannot. It's the opposite default. And there are times, such as in healthcare law in the US, where the law does come in and say, no, you may not do that. But those are exceptions to a general rule of permissiveness. So I think in substance, many of the laws we're seeing, by not requiring the same kind of lawful, transparent, fair processing as the GDPR, by not changing that default, by being driven by an opt-out rather than an opt-in mechanism, should not be seen as heirs to the GDPR, but rather perhaps first cousins once removed. And I'll stop my sort of basic overview of my views there.
Thank you, Bill. Let's hear from Julie next. Julie, could you talk a little about what you see happening from the business perspective between the CCPA going into effect, the new state bill that Bill just mentioned, and ongoing discussions in DC about a federal bill of some kind?
Sure, happy to, and thanks so much to CPDP for inviting me and for Cordell for sponsoring this panel. This is, I think, my 10th CPDP. I loved coming to this event when I was a commissioner, and it's still one of the best privacy events globally, so I'm just thrilled to be here. You know, I will talk about it from a business perspective, but frankly, I cannot forget my 30 years in government service, including 6 years as an FTC commissioner, but also, prior to that, 20 years at the state level, running the State Attorneys General Privacy Working Group for many, many years, and leading consumer protection, competition, and privacy organizations within the Vermont Attorney General's office, as well as the North Carolina Attorney General's office. So I have a lot of experience with state laws, and it's going to be hard for me to leave that behind, and indeed, I don't think I should. So I thought very quickly you all might be interested in what is actually happening on the ground in the states before I get to the federal government. So I've got a couple of slides. Let's see. All right, yours works, mine doesn't. I'll take this. So first of all, there are about 22 total states that are considering privacy legislation right now in the United States. The reason why you see some that are light blue, those are states that are considering bills that would set up a commission to study what should happen with respect to data protection or privacy. The reason why California is colored in here is because as everybody in this room knows, California did pass a law known as the California Consumer Privacy Act. Some people call it CCPA 1.0, but California is also now considering modifying that law, and the proposal through an initiative was launched even before CCPA became live and effective. It is known as the California Privacy Rights Act, or some people call it CCPA 2.0. I'll come back to that in a minute. Washington State is also listed here, but many other states as well. Because there's a lot of activity in the states with respect to facial recognition, I thought I would also show this slide, which shows the number of states that are considering right now some kind of legislation dealing with facial recognition or are considering some kind of commission. The reason why this is important, and I think many of you know, first of all, there is an aspect to which privacy is fundamental in the United States, and I'm just not talking about Microsoft's position. We're a global entity in many ways. But when it comes to the Fourth Amendment and search and seizure, there is a fundamental right with respect to individuals as in terms of how government collects and uses their data. So I think that's an important concept to keep in mind, and you're seeing in many of these facial recognition bills, they are very much focused on how government, how law enforcement, and other governmental entities are using face data. But let's go back to baseline. Can I go backwards? Maybe I can't. There we go. Okay, but I'll keep this one up here because I think what is happening in the states is very important, as Bill alluded to. In many ways, for some entities, it is the impetus, that is California's law in particular, but also this activity that you're seeing across the country is an impetus for some people to be considering federal law. California's law, or CCPA 1.0, the one that is currently in effect, broke the logjam in the United States in terms of baseline privacy legislation. And I have applauded it in blogs. Microsoft has said that it is a good first step, and we are very supportive of it. We are implementing, just as we're implementing GDPR's core rights globally, we are implementing California's core rights throughout the United States. You know, if you believe that privacy is a fundamental right, you have to, walk the walk as well as talk the talk, and that is what we do, or we certainly try to do. California's law is it has some DSRs, data subject rights. It does not have all of them. It has a requirement that companies provide consumers with the ability to opt out of sharing of information with third parties. It does not have a provision dealing with the ability to opt out of processing all up. So my perspective, and this is something that I testified to in the Senate last month in the Senate Commerce Committee, is that California, again, is a very good first step, but it is not business model neutral. So that if you are a company that is vertically integrated in terms of ad technology, you don't necessarily have to provide consumers with the right to opt out of data sharing. But if instead, in order to reach consumers, you're a small business, a medium-sized business, you need to use the current or hopefully future ad technology ecosystem, you do have to offer up this ability to opt out of data sharing. So one of the concerns that we have about California is we would prefer to see it shift to a business model neutral format. And indeed, that is what you see, if you can understand it, in the new initiative that is going to be voted on by the people of California in November of 2020. There are other provisions in California's law that are super interesting. It does have a private right of action. It's a limited private right of action only for security breaches. Washington's bill, as Bill alluded to, is a bill that Microsoft was, among many other stakeholders, involved in helping to develop. We were one of the stakeholders that was at the table. We view Washington's current bill, the one, indeed, it was just modified, and so there was a new version that was introduced just this week. We view it as a comprehensive privacy bill for the United States. It has the full suite of data subject rights. Unlike California's law, it also has, or the law that's on the books, you'll see some of this in the new initiative, CCPA 2.0, which needs to be voted on. But Washington's bill also has corporate responsibility provisions that are inspired by GDPR, no question. Data minimization, purpose specification, no secondary use unless it's compatible or you have some kind of information flow consent coming from consumers, security provisions, special protections for sensitive data, and requirements that companies engage in data protection impact assessments. So it really is quite inspired by GDPR. It does allow for a private right of action. There's a little bit of a misnomer about whether it does or doesn't, but that comes in a special way under the Consumer Protection Act of Washington State. There are lots. So these other laws that you're seeing around the states in the United States, some of them are inspired by Washington's format and model. Well, that is Washington State's. Some are inspired by California's model. You're going to see this roll out over the United States now, I think, for a few years. I was very involved, as I mentioned, with states' development of privacy laws for many years, and we have seen this movie before in the states of the United States with respect to data breach notification laws. Began in California in around 2005, ultimately over a period of about 10 years rolled out to all the states. I guess it took a while for the last state, but the last state has now passed a data breach notification law. And there was a lot of conversation in the country, in the United States, about this patchwork quilt of different state laws. But now that is what we have, or what I would say is a robust regime on data breach notification in the United States. And it is driven by the states of the United States, not the federal government. But it is true that some of these concerns, not by Microsoft but by others, about this activity at the state level is an impetus for the federal government, and that is Congress in particular, to be looking at federal legislation in the United States. There's some really good proposals out there that members of Congress have put forward. Senator Cantwell and Senator Wicker. Senator Cantwell has introduced a bill. Senator Wicker has a draft. They are the ranking member, Senator Cantwell, and the chair of the Senate Commerce Committee in the United States. That is the committee with primary jurisdiction over what we would call baseline privacy legislation. They're very strong bills. On the House side, the House Energy and Commerce Committee is currently working on a bipartisan bill as well. So there's a lot of activity in the federal government. and in Congress to try to enact a law. The two areas where there will be the most debate, because if you look at these bills, they actually have so much in common. Right now. They're very robust in terms of corporate accountability and corporate responsibility, including concepts like a duty of care, which I know Woody will probably be addressing, and which Microsoft supports. The two areas that will be the last to be decided and that will be the hardest will be a private right of action and preemption. And my position has long been, when I was a commissioner and when I was a state assistant attorney general and deputy attorney general, I always said a federal law can be preemptive, but it needs to be worthy of preemption. It needs to be a strong law. And that's the position that Microsoft is taking as well. So with that, why don't I pause and let's hear from the other speakers.
Great. Thank you, Julie. So Julie mentioned Woody. Woody has also written a recent paper on this issue called Privacy's Constitutional Moment and the Data Protection Dilemma, also available on SSRN and forthcoming in the Boston College Law Review. He's an excellent co-author, too. Woody, what do you see potentially happening in the U.S.?
Sure. So you asked three questions. What's the lay of the land, what's likely to happen, and what would I want to see happen?
Correct.
If I could choose. The lay of the land, I think, as I see it, is even though Bill said that there's not likely to be, we're not on the very precipice of a sort of overwhelming barrage of statutes. One of the things I do see happening is that America's privacy identity is about to firm up, I think. And so for a while, it was sort of unclear the exact approach that American lawmakers wanted to take on privacy. Like, is it data protection? Is it consumer protection, to borrow Bill's sort of dichotomy? And it seems that the answer is sort of firmly driving in the direction of data protection. And so with that, then I'll say what is likely to happen is that I fear what is likely to happen is that no matter what we get, even if we have what is seen to be the sort of even if the most robust version of what's sort of been offered now gets adopted, then my fear is that it's going to result in what you and I have referred to as GDPR-lite. A version of the GDPR that mimics the GDPR in a lot of very important ways, but doesn't necessarily have the full scope of protection that might be afforded by the GDPR. And the reason why is based on a lot of fundamental differences, of course, between Europe and the United States, primarily that the wind in the sails of the GDPR and what really animates, I think, a lot of interpretation and a lot of enforcement mechanisms is the idea that both privacy and data protection separately are seen as fundamental human rights in Europe. No such thing exists in the United States, but for the Fourth Amendment, which of course only applies to government actors and in interesting ways. And the second reason why I think we are bound to receive a GDPR-lite, even under the most robust version of the bills that have been introduced, is the fact that the default presumption, as Bill, as you articulated, in the United States, in all of the bills, is still going to be allow data processing unless there's a reason to prohibit it, rather than a default presumption against it that then must be justified. And I think that manifests itself in important ways. Other important differences include the Spokio decision in the United States, which requires a showing of concrete injury, which we are sort of remaining to be seen what that is, but it could present an obstacle depending upon the nature of the legislation. And then finally, and importantly, the U.S. commitment to freedom of speech plays out in different ways than in Europe, and I think that's going to be something that will always be sort of present as we consider what is and isn't permissible in the United States. Now, let me move to the third question, which is what do I think what would I would like to see happen? Now, given that argument I just made, you might think that what I would like to see happen is a GDPR perfect, right? GDPR robust, GDPR mirror image. But I don't think that's actually the optimal situation either. In fact, I think that even if the United States were somehow able to get a GDPR perfect, it wouldn't be enough. it wouldn't be enough to, I think, address a lot of what's really creating significant concerns for people, putting people in vulnerable positions, and corroding a lot of important social institutions. And let me say what I mean by that. First, the reason I think that even GDPR perfect is not going to be enough is because I think one of the significant weaknesses of the GDPR is its prioritization of the concept of informational self-determination and privacy as control over personal information. I think that while it's important to think about the ways in which control furthers the autonomy of people, prioritizing control as really the ideal function of privacy results in some significant drawbacks, because control is the way it is effectuated is through mediated environments, and if it is done by that, then the control that we are given is to a large extent illusory, because we don't choose the buttons that we get to pick. We don't have a sort of empty text box that we can write in whatever we wish controllers to do with our information. We have to deal with a set of pre-selected options. And so I think we risk feeling more empowered than we actually are, given the sort of hidden constraints of mediated environments. Control is also overwhelming as a concept. So even if a company were able to perfect the notion of control, that were given to us in an idealized state, and we feel empowered in the most impressive way after contemplating the decision that we wish to make and effectuating that decision, that is only one decision that we need to make among hundreds, if possibly not thousands, and we only have 24 hours a day and we need to sleep. And so given resource limitations, control is overwhelming. And so I've said in other areas, the problem with thinking about privacy as control is that if we are given our wish for more privacy, we are given so much control that we choke on it. And so I worry about this sort of relentless pursuit of control. And then finally, I think that thinking about privacy and data protection solely in terms of control is myopic. Because what it doesn't, because it's so individually focused, a lot of what it misses is the fact that there are collective harms that can result from mass data processing, that it misses a lot of the sort of social wisdom that we have. And this actually leads me to the next reason why I think GDPR perfect might not be sufficient. And that's because data that is fairly processed can still be harmful to people and to society, generally speaking. So it can still be used to manipulate us, even if it was fairly processed, to sort of wheedle us into it, to even giving more information. It can still be used for harassment purposes. It can still be used in ways that are corrosive to democracy in large platforms, all of which is the GDPR is a poor vehicle to try and address, even though the desire for personal information is what is driving a lot of these systems. And so without an attentiveness to what's driving the collection of personal information, my fear is that GDPR addresses some of the problems, but not all of them. And then that leads me to the real concern I have, which is that where we're headed with this is, I fear, because of the way in which the United States merges conversations about privacy and conversations about data protection in ways that seem distinct in European conversations, my fear is that we will adopt either a patchwork of state legislations all built around either California's model or GDPR's model, or we will have a piece of federal legislation that looks a little bit like an omnibus data protection rule, and we will then sort of dust off our hands and say, job well done, having exerted the political capital necessary for such a venture and having none left over to then address a lot of the other remaining really important issues of our time, particularly those addressed in the massive power that mediated entities have, that in Julie Cohen's book that she addresses, that I highly recommend to all of you. And so the third question is what I want to happen. I will very, very briefly say, if we are going to get comprehensive legislation, that data is just one of 4 parts that we should address. We should have organizational limits that deal with structural power and structural allocations of power. We should have conversations in a national legislation that talks about perhaps personal liability for executives, or ways in which we partition businesses, or anti-competition concerns. We should have relational obligations, so duties of care, which is one that was mentioned, which I think is very important. But that's duties of care is just one part. A duty of loyalty, I think, is very important to help shore up some of the limitations of the current data protection models, which would be an obligation to refrain from unreasonable self-dealing, not all self-dealing, but unreasonable. Data, of course, following the data protection model, and then finally focusing on the externalities of the personal data industrial complex. The pursuit for personal information creates all sorts of externalities. It drives a lot of potential environmental harms. It saps our attention. It has potentially negative effects on our well-being, and it has corrosive effects on our democracy and our ability to discuss information in a way that can help us with proper self-governance. And so unless an omnibus rule addressed all four of those provisions, then I fear that we will be engaging in an endeavor that leaves us wanting to cover additional areas.
So you're calling for modest incremental reform then? Or not. Great, thank you, Woody. Let's bring in our European panelists at this stage. I want to be respectful, since they're both government officials, of the ways that your government offices place more limits on what you can say, certainly than Woody just did. But I'm really interested in your thoughts, much less on the lay of the land in the United States, but given your particular expertise and your positions, what might be necessary out of this stew of proposals and possibilities in the United States at the federal and state levels? What might be necessary for adequacy or some other effective derogation for sustainable cross-border transfers, realizing, of course, that our friends in the robes in Luxembourg will likely have something to say at least about a portion of this sometime in the next few months. So Helen, from your position as DPC and a DPA, what would you like to see happen in the US?
So what we would like to see, and sorry, I should just say, Neil, that we're independent of government, and so I don't feel in any way constrained in terms of what the Irish government might think of a US federal privacy law in terms of any opinions I'm going to express. So from the perspective of the Irish Data Protection Authority, we would like to see a baseline comprehensive federal data protection law. I entirely agree with Woody. It shouldn't be GDPR-lite. It shouldn't be GDPR-perfect, which doesn't exist. It should avoid all of the pitfalls that the GDPR has, and I'll outline a few of them. And some of them are easily avoidable, of course, in a US context. Failing a comprehensive baseline federal data protection law, we would like to see a law that regulates the platforms that includes data protection elements. So in recognition of the point you both made in your constitutional moment paper about data protection being myopic, perhaps there should be something more multidisciplinary in terms of regulating the platforms. And of course, the reason I'm emphasizing the platforms is that we regulate them, we are the lead supervisory authority in the EU. And even though the GDPR recognizes this legal construct of EU data controllers, and all of these big platforms have their main establishment in Ireland, so they're deemed the EU controllers, making my office responsible. The reality is, in most cases, and there are exceptions, and Microsoft to a large extent is one, the engineering, the creation, the innovation, the design of all of these platforms has happened and is happening exclusively in the US. And exporting the platforms as they are to the EU and then trying to retrofit them, which is what's happening, we're a long way from privacy by design, for the GDPR, has very limited positive outcomes. So when, for example, Facebook would have arrived in the EU and in Ireland in 2008, 2009, my office would have engaged in lots of interaction in terms of reversing facial recognition and auto-tagging of photos and rolling back on features that were deemed incompatible with the EU directive that was in place at the time. But that's very painstaking work where we can't really see. And if there was a law in the US that filtered the platforms before they were exported, this would, of course, be a much better scenario. If you look at whether you agree with her thesis or not, Susanna Zuboff's tracing of the history of what she, of course, calls surveillance capitalism, she goes back to 2001 and says it was given birth to by Google at that time, where they started to use data logs, basically a waste product of what they were doing, and turned that into what became online behavioral advertising. And she points out, and I think it's a matter of fact, that they were simply unhindered by any laws in terms of what they began to do. And of course, when those platforms were exported to the EU, we lapped them up like everyone else. Social media was so novel and new, and users really were unaware of any dangers, regardless of EU data protection laws. So I think a law that sets down some standards, avoids pitfalls of the GDPR, but includes concepts of privacy by design, engineers the products for purpose limitation, data minimization, and so on, would be extremely positive. Just in terms of some of the pitfalls that I think could and should be avoided, GDPR is technology neutral, principles based, and of course this is in part, it has to be that way because it's reflective of the fundamental right to data protection, and it applies to personal data processing in all scenarios. So it's not just for regulating tech platforms, it regulates governments, it regulates voluntary sector, it regulates all of the areas that have sectoral laws in the US. So it would be impossible to write a law big enough that wasn't technology neutral. But what that does is make enforcement, it creates extra steps to demonstrate that the principles have been breached. And so the more specific the provisions can be made, if there are policy decisions that can be identified, the better in terms of enforcement. So for example, as a data protection authority, you'll be aware that we regulate and prosecute under the e-privacy directive as it is currently in the EU. We take regular prosecutions in the district court in Ireland because the provisions in e-privacy are very specific, and when they're breached, it's a fairly easy case to prove. Under the law enforcement directive that has applied also in Europe, not often talked about since May 2018, and which regulates essentially any public sector entity in the EU that is investigating, detecting and prosecuting offences. So law enforcement, it effectively regulates law enforcement authorities. Again, we've already made decisions, used corrective powers under our 2018 Act in respect of that law, because it has specific provisions around when data protection impact assessments are required, when surveillance technologies like CCTV, drones, etc., are being deployed. So the more specific, the easier, clearly, you can tee up enforcement. Just to say a few more things then, before I hand off. I think it's likely, I've never heard it suggested that it would be any other way, that a federal privacy law in the US would focus narrowly from our EU point of view on commercial contexts. And I think this is likely to be a positive in terms of the results. As an authority, we are dealing with multiple decisions and investigations at the moment, for example, around individuals who want to use their right to erasure to have themselves removed from Catholic Church sacramental registers. And these are very complex investigations. There is personal data processing involved. It overlaps with canon law. And we must invest time, just as we must in investigating a Facebook issue to resolve these. And we have multiple complainants on these issues. Employment disputes, we spend an awful lot of time around personal data processing issues, around employment disputes. We also had a very long-running complaint from an Irish individual. I don't know if any of you know much about the Irish language, but it has accents to elongate certain vowels, like many languages do, we had a complaint from an individual that his data was inaccurate from a data protection point of view and should be rectified from a data protection point of view, because on a state database his name was capitalized and the accents couldn't be included. Again, an awful lot of time spent on that case and proceedings threatened against our office. So I think if you don't want to have a body dealing with those issues, then commercial context. I would say having a dedicated authority, not just to enforce data protection and to line up with other global data protection authorities, would be a good idea, but really around the idea of guiding. To the extent that any law is going to be principles based, the guidance is critically important. And then the last thing I'll say in terms of considering what differences from the GDPR a US law might implement, I mentioned earlier those individual complaints. So while we're called supervisory authorities in the EU under the GDPR, in fact, supervision is only a fraction of what we do, because individual complaint handling is an obligation on us, and individuals have a right to a judicial remedy where we fail to deliver on that. So as an authority alone, I am dealing with thousands and thousands of complaints. I've given you a tiny few examples of the nature of some of them. Some of them can be so minor in nature, but the GDPR doesn't set out any prioritization in terms of what's an important individual complaint. Every complaint is important to the individual. So I think considering that idea of would you want the law and any entity you set up to enforce it to deal with individuals' complaints, or do you want them focusing on the big systemic issues?
Thank you. I have one narrow follow-up question, just to clarify. You said one of the things you would like to see would be a dedicated authority in the United States. Do you have a preference, or does your office have a preference between it being the Federal Trade Commission versus a new agency, or would that depend on the details?
We've no preference, and we've worked so well and closely and admire so much the FTC. The only advantage I can think to a separate dedicated agency goes to staffing it up, having a whole new profile and kicking it off as something new and targeted in terms of requiring a step change from the entities it regulates. But no, we've no knowledge really of what the whole range of factors that would need to be considered there is.
It's unclear whether Congress has that knowledge either. But great. So thank you, Helen. So finally, Bruno, same question. From your perspective at the Commission, what would you like to see happen in the United States?
Thank you very much. And I will try to answer that question as the only non-independent person on this panel. So first I wanted to say maybe a couple of things on the transatlantic relationship in the area of data protection privacy. It is far from being it's far from being a one-way conversation of process. It's actually a relationship made of mutual influences to a much greater extent that it is often said, often presented. First, because, as you know much better than I do, some of the most fundamental, some of the core data protection modern privacy principles were developed in the 70s, were developed first of all or primarily in the US. Second, because when we developed the GDPR, we actually drew inspiration from a number of concept notions or even rules that have emerged in the US. Rules or safeguards, I'm thinking for instance of data breach notification, which didn't exist in the EU legal system, but also principles such as accountability and the risk-based approach. We have also shown actually that the EU and the US should and can agree on a number of principles, a number of safeguards, a number of rights. We have shown this in the, if you want, commercial area to an arrangement such as the Privacy Shield, which is, yes, under litigation and challenged currently, but that's healthy. That's meaning it's a system based on the rule of law. But what is interesting and what is often completely underestimated is the part of the privacy shield which is not actually being challenged. Probably it's less sexy than the ombudsperson, than national security access, but the day-to-day adherence to the privacy shield is about compliance with principles such as purpose limitation, such as data retention, such as the protection of sensitive data, such as the respect and exercise of some individual rights. That's also often, I must say, neglected by many of our data protection authorities, unfortunately. And on that we have been able to agree. We even have been able to agree on a full catalog of rights, safeguards, principle in a sensitive and complex areas such as data protection in the field of law enforcement cooperation. The umbrella agreement is so far the only binding instrument at international level that is fully dedicated, is completely dedicated, is all about how data protection should be protected, how privacy should be protected in the area of criminal law enforcement. That's also, I would say, very significant. You will have noticed that this is an area which, surprisingly, so far so good, I don't know, is one of the few areas of the EU-US relationship where there is actually some, and maybe even a great deal of continuity between the previous administration and the current administration. My colleagues working on, I don't know, climate changes, on trade, have a completely different experience. What is also interesting in this conversation is that some of the issues that the U.S. is addressing today, or is facing today, or has to deal with, has to engage with today, are the very same issues we had to address when we proposed the GDPR. Essentially, fragmentation of the regulatory landscape and the need for, if you want, common rules of the game, both in terms of what has been very well explained when you see these maps with the dark blue and the light blue, but also common rules of the game, and that's where the question about the comprehensive legislation comes in, common rules of the game to ensure both coherent protection across sectors, across industry, and also facilitate the movement of data across sectors, across industries. So where do we believe we go from him? First, we still think that actually the US and the EU, by building on what we have already achieved and by increasing convergence between our approach in the area of privacy, that can bring a lot of mutual benefits in terms of course, facilitated data exchanges. In also, data exchanges are part of almost any human activity, trade, law enforcement cooperation, public regulatory cooperation, social interaction, communication. And increasing that convergence will also, of course, further strengthen the instruments we have put in place in the last years. And interestingly also, I think there is today more space for this dialogue and cooperation that there was even a few years ago. When I started working on this issues, the question was, why? Why are you doing this in Europe? Basically, you obsess, you're losers, you don't get it, etc. Now the question is, it's outdated privacy. Who cares about privacy? And I'm talking about, I'm old, but I'm not so old. I'm talking about 5 or 6 years ago when I moved to this field. Now the question, and the question at my level, the question when I'm traveling with our commissioner is no longer why, is how. That's a big difference. And that's and by the way, there were the same sort of ideological obstacles. I mean, that was a very ideological, to use an understatement, conversation, debate, and it is much less today. Also on our side. On our side, it was so easy to say, the US, they don't care about privacy. They don't have privacy protection. They don't, often still, we can hear things of that sort. even in the mouth of people who should know a bit more about all this. But I have the impression that we are in a much more rational or operational type of conversation today. So that's what also makes us quite actually optimistic in this area, more maybe than in other areas, and that's also true at global level. At a time where in many fields you have increased divergence, fragmentation, if not opposition, this is an area at international level where we see actually increased convergence. And then I will finish by the A question, which of course I'm often get that question about adequacy, what adequacy means, what is I will try to be very brief. It's probably I have already spoken too long. First, let's also say what adequacy is and what adequacy is not. Adequacy is not about and has never been conceived as a test of identity, and that's always very important to stress. Even the famous French judgment, everybody talks about one sentence of the French judgment or one phrase of the French judgment, which says that you need to have a level of essential equivalence. But that phrase is immediately followed by another phrase which says that that level of essential equivalence can be achieved, of course, through different means, through different instruments, through different approaches. And it's also very, of course, this is a strict test, but it's a strict test for a very good reason. Let's not also forget what are the advantages that adequacy brings compared to other transfer tools we have. Basically, adequacy is an instrument by which you are assimilated to a member country of the EU while not being subject to the rules, to the common rules we have agreed together and we apply together in the EU. And that's why the degree of similarity has to be quite of a quite high level degree. And adequacy is about looking at the system in its entirety, in its globality, and considering whether, even through different mechanisms, that system delivers a sufficiently comparable level of protection to the one guaranteed in the EU. And of course, this can be done, and we have shown with Japan and others that this can be done in very different ways. But there are still, I would say, some fundamental elements that we need to look at. One is, of course, that there must be preferably an overarching legislation, because data moves, and first, before moving internationally, it first moves within a system, as I said, across business, across industries, between the public and the private sector, and we need to ensure that continuity of protection. There need to be a core set of data protection principles. Many of those data protection principles have been first developed actually in the US. What was very interesting is what, of course, you said that one of this principle we need to look at is whether, and that's one of the main difference between our approaches, whether you have a requirement that you need a ground for processing. Mm-hmm. Right. And the issue, and once again, that's where it's interesting to think about adequacy as something which is assessed where you assess a system in its entirety, in its globality, and you don't assess one element in isolation from the other. If you don't have systems where you need originally, if you want ground for processing, then you need to have probably much stronger safeguards down the line, for instance, in terms of purpose limitation. That's the type of balance, for instance, to take just that example, we would need to assess. Now, a further element, I would say bag category, which is very important, is individual rights, and those individual rights needs to be, of course, enforceable individual rights. And then finally, a independent supervisory authority with effective powers to ensure the enforcement of those rules. And here, I can only echo what Helen said. It's not for us to this is not a beauty contest to pick up who can be the best one, etc. But there is still an issue which is very important for us and which goes back. In general, I don't believe too much in sort of dogmatic debates whether our approach it is so important that our approach is a fundamental rights approach compared to other approaches that are more consumer law based. Because I think that at the end we believe in the value of human rights generally, including the rights of the right of privacy. But there is a dimension of that approach which is very important for us, is that any individual complaint must be dealt with and must be resolved, because it's about a fundamental right, and therefore standards and questions such as criteria such as harm, etc., should not prevent the exercise of privacy rights and the resolution of individual complaints. So yes, there are some still, I would say, some we wouldn't call them obstacles, but issues on which probably we have some differences that are more relevant and matter more than other differences. But I want to conclude by saying that we need to continue working on this, and even more today, because as I said, there's a strong demand for international standards in this area. And still, I believe the EU and the US have an interest to shape and to set those standards together, rather than having others setting those standards, because most probably they will not be standards that we would like very much. Thank you very much.
Well, thank you all. That was an extraordinarily, we're not finished, but that was extraordinarily interesting and extraordinarily comprehensive, even if it perhaps did not have essential equivalents to a 5-minute time limit from each of you, which is an occupational hazard with a group of panelists so talented, so brilliant, and so verbose. I want to leave time for questions, but I did want to have an opportunity, if any of our panelists have a burning desire to disagree, Julie is sort of twitching amiably with anything that has been said. Julie.
Okay, I will try to be super quick. So there's so much I agreed with respect to what Woody said, but there's some things I very much disagreed with, and I just will try to do this as quickly as I can. It is absolutely the case that focusing just on consumer choice and consumer control is a huge mistake. Consumers right now, or users or people, are just overwhelmed. There are way too many websites that they're using, way too many connected devices they're using. They cannot deal with privacy just by themselves. We cannot put all of the burden on users and on people. Companies must take responsibility, and that is something that you see not so much in the California law, but you definitely see it especially in the new version of the Washington Privacy Act, and you also see it in the federal bills. By the way, I mentioned duty of loyalty, but I really meant the suite of duties that Woody was so instrumental in ensuring were part of the federal legislation: duty of care, duty of loyalty, duty of confidentiality. All of those are incredibly important. But here's the thing. When you're a privacy expert, you are essentially a hammer. And to hammers, everything looks like a nail. If we try to put into to say that we can't have a federal privacy law or a state privacy law unless it deals with competition, disinformation, harassment, or abuse, we will not have a law in the United States. So if we want to be pragmatic and actually get something done, then I think what we're going to need to do in the United States is recognize that privacy and data protection does not necessarily have to include all of these other issues, which are incredibly important. And I'm not saying they shouldn't be dealt with. They absolutely should be dealt with. But this is the same problem we had with data breach notification in the United States. Everybody wanted to pile so much more into it that nothing has gotten done for 15 years on data breach notification. We now have a moment in the United States to actually pass significant legislation both at the state level and at the federal level. I don't think we can let the perfect stand in the way of the really, really good. And that is what you're seeing in these bills right now. Other things I just want to mention really quickly. I love the fact that Helen mentioned that having privacy and data protection as a fundamental human right is not the bed of roses that everybody thinks it is. And there actually are some downsides to it. And I think your point about needing to having a regulatory agency that must, by its constitutional makeup, because privacy is a fundamental right, deal with every single complaint actually can be quite problematic.
Yeah.
So I thank you for calling that out, Helen. I don't think I've heard you say that before, so I very much appreciate that. Other thing, just really quickly about a separate agency, fully agree that I do think the FTC is the right agency. I think setting up a new agency in the United States, we've seen with the Consumer Financial Protection Bureau, looks great for 8 years or 7 years or so, and then it can be very problematic. Setting up a new agency in the United States is super, super hard. The FTC has been around for over 100 years, and so it has a lot of longevity, but it absolutely is the case. I testified last month. It needs 500 new employees to deal with privacy. Literally, it needs to grow by almost 50% to do the job that the DPAs are doing in Europe. If you count up all the numbers that they have, Helen's shop and Liz Denham's shop and Marie-Laure Denis' shop in the Canil, you're talking about a lot of people focusing on privacy. And that is what the United States needs to do. It really needs to up its game to get the job done. Oh, and I have a blog coming out in about 4 hours on the Washington Privacy Act and what we think it will bring to the United States in terms of a robust law. So please take a look at my blog.
Right. I've been given the 5-minute warning. Are there any burning, a high threshold, no burning comments from the panelists? Questions from the audience? I know our excellent staff have microphones and will be circulating.
Oh, hi, thanks. Colin Bennett from the University of Victoria in Canada. Lovely panel, lovely to hear the latest chapter in this long story. I wondered if I could just, by the way, we in Canada you're going to be seeing some significant reforms in Ottawa under our new government to pip it down. So keep an eye on that. But I also wanted to sort of direct your attention to the North American economy. This is obviously a US-EU kind of conversation for good reason. But in the context of the USMCA, we call it the CAMUS, and particularly the issue of onward transfers, right? Which is of course extraordinarily of interest to the European Union. And I just had a question about whether in all of this policy activity you're seeing any kind of sense of a convergence or a common approach to the question of how US data will be protected outside of the United States.
Thoughts on that?
Because you can understand why that's of great significance to Canada.
Well, as you know, the USMCA does promote and thinks very highly of CBPRs and is very much trying to adopt kind of the APEC approach to data transfers. So I do think that there is a focus on that. I don't know, in my conversations in Congress, as I'm testifying and talking to various members, as well as in state houses around the United States, I haven't heard that issue raised so much by policymakers, but it is in the trade deal.
I think we have time for at least one more question. This is not an admonition on Colin by any means, but if we keep the questions short, we can hopefully get more than one question in.
I will. Paul Breitbart, Trustark and Maastricht University. I agree with Bruno that every complaint should be heard, but one of the obstacles did not really get mentioned in the panel, and that is that all these state laws are limited to residents of the state only. So non-residents of a state or non-US persons would not have those rights.
Or companies based in the
Or
state.
companies based in those states. But as a European, for example, I cannot file a complaint under CCPA likely. So what do you expect for the federal legislation?
That's not true. So just really so a couple things. You can file a complaint against a company that either says it's going to comply with CCPA or that is based in California. So Europeans can file complaints, just to clarify that. I do think, to get to your point about what's going to happen in federal legislation, And by the way, that's also true in Washington State. It applies to companies that are based in Washington State. With respect to federal legislation, I think to a certain extent what you're getting at is the private right of action and what will individuals be able to do. There is a lot of conversation about that. We have promoted the notion that companies must have an administrative process where consumers' complaints about they're not getting their subject rights or whatever can be heard. That needs to get escalated, and then they need to have the ability to go to court to get injunctive relief. One other quick point about the states. While it is not usually required in the states that every complaint be heard, every state attorney general's office runs a consumer mediation program, and almost all of them do mediate every single complaint. The Federal Trade Commission is not required to hear every complaint and does not. It only focuses on sort of the complaints that rise to truly a federal case.
I think we're almost out of time. I have one quick question for the panelists. A one-word answer is required. Actually, you can have 2 words, because it's a 2-part question. First, do you think we will see, this may be more for the Americans, do you think we'll see a federal law passed in the next 12 months, and will you be happy with it? Julie?
No, so I don't have to answer the second question.
Well, no and no, right?
Well, no, there will not be a federal law in the next 12 months, but there will be one within 3 years. And yes, I think I will be happy with it. It won't be perfect, but it will be good. And it might be very good.
Helen, you're welcome to pass this one if you are. Woody?
No.
Bill?
6 words. No, not in 3 years either.
Well, now I feel terrible for having subjected you all to an hour and 15 minutes of a panel on the forthcoming U.S. privacy legislation. I think it is
Federal U.S.
Right.
I think the states,
Oh,
as
yeah,
Julie's
yeah,
map
yeah.
demonstrates,
Okay.
are going to be doing lots of
Oh,
things.
yeah,
That's where the action, in my opinion, really is.
Well, that was intended as a joke, right? I think what we certainly have seen is something is happening, and even inertia, given the extraterritorial effect of the GDPR, is going to create entropy in the U.S. privacy regulatory system. And I think, obviously, this is a very, very important issue. Thank you to my panelists, to our panelists, and thank you all for coming. Please join me in thanking the panel.